Let us understand that this is a constitution which is founded in a history of multiple conflicts. Freedom of expression and national integrity, personal liberty and political stability, special treatment for some segments of society, and equality for all. When we jail a cartoonist for sedition, or when jail instead of bail is given to a blogger who is critical of our religious architecture. When a mob lynches a person for the food that she or he eats, it is the constitution which is lynched. When we deny to human beings the power of love for reasons of religion or caste, it is the constitution which is made to weep. Our constitution does matter. The Indian constitutional project did not commence on 9 December 1946 when the Constituent Assembly sat in New Delhi for its first session. It first echoed in the battlefields of Bengal in the 1857 rebellion. Lokmanya Gangadhar Tilak, whose famous trial took place in this courtroom, was among the first to call for Purna Swaraj. For many decades prior to the coming into the force of our constitution, the Indian self-rule movement was a mass movement and encompassed many sections of society. The call was simple: a governing document of the people, by the people, and for the people. The constitutional culture in India predated the coming into force of our constitution. Before the advent of our constitution, a well-known demand had emerged to establish, through the participation of the people, basic rules and principles of behavior which would constitute universally binding legal norms. The Constitution was to mark a transfer of the power to steward the destinies of its citizens. So the first important facet of the Constitution which I want to emphasize, that this is a document which marks the transfer of colonial power. The Constitution was to put in place an organic structure that would sustain the country's independence and freedom, equipped with the tools for social revolution, as noted historian Granville Austin called it. So a parallel movement was taking place during the times of the freedom movement, which we shouldn't lose sight of. The parallel movement, together with the movement for freedom, was a movement for social emancipation. The movement which was begun by people like Dr. B.R. Ambedkar, but even before Babasaheb Ambedkar, by people like Phule. This potential of a constitutional document in steering the course of the society it governs lends it paramountcy in comparison to statute law. A quote by Carl Schmitt comes to mind. The essence of the Constitution, he says, is not contained in a statute or a norm, but in a prior and fundamental political decision by the bearer of the Constitution-making power. In a democracy, this is a decision by the people. A constitutional culture is based on the understanding that a constitution unifies a population beyond those in one's immediate sphere of acquaintance, and that whatever be our differences, this is something we have in common. When the Constitution was adopted, there was a consciousness that in writing its text, India was finding a way to resolve major substantive debates and disputes over norms and values. In granting people power over their destiny, the Constitution placed the individual at its heart to guide the functioning of the democratic institutions which it has put in place. Our history of constitutional drafting is replete with anecdotes which illustrate that there was an attempt by the framers to stake ownership over that document. Our framers did not place the Constitution for approval before the British Parliament. Following the Irish precedent, Article 395 of the Constitution repealed the Indian Independence Act. The framers repudiated the source which authorized them to enact the Constitution. This was a symbolic denial of Indian independence being a benevolence of an imperial parliament. These actions of the framers ensured that the chain of constitutional validity did not extend to the crown in parliament. They delivered a completely, pardon my long word, they delivered a completely autochthonous constitution, a homegrown constitution rooted in our soil. The Constitution owed its validity and authority to its own people, rather than to the fact of its enactment by a foreign legal process. In way fashion, we the people, through the members of the Constituent Assembly, came to be the source of authority of the Constitution, rather than the Indian Independence Act enacted by the British Crown and Parliament. The advent of the Indian Constitution thus marked the coming together of a population, the culmination of a desire for self-governance. It represented a bottom-up approach where the people granted to themselves their structures of governance. In Nani Palkhiwala's words, the Constitution represents the charter of power granted by liberty and not the charter of liberty granted by power. Liberty is not a gift of the state to the people. It is the people enjoying liberty as citizens of a free republic who have granted power to the legislature and to the executive. The Constitution was required to take into account multiple conflicts. Let us understand that this is a Constitution which is founded in a history of multiple conflicts. Freedom of expression and national integrity, personal liberty and political stability, special treatment for some segments of society and equality for all, property rights and social revolutionary needs. The people who work the Constitution may go terribly wrong, and sometimes they do, as when we jail a cartoonist for sedition, or when jail instead of bail is given to a blogger who is critical of our religious architecture. When a mob lynches a person for the food that she or he eats, it is the Constitution which is lynched. When we deny to human beings the power of love for reasons of religion or caste, it is the Constitution which is made to weep. That is exactly what happened yesterday when a groom belonging to the Dalit community was asked to climb down from a horse in a wedding procession. Let us make no two bones about it. That is the Constitution which weeps when we read of such incidents. To the wisdom of our people, the Constitution trusts. The trust is broken at our peril. The most fundamental struggle was between Parliament and the Supreme Court over custody of the Constitution. The central issue being whether Parliament's power of amendment was complete and unrestrained. In the initial decade of the Indian independence, of the nation's independence, a stronger central government with far-reaching powers had assumed importance in order to drive socio-political revolution. The birth of the nation was into what Granville Austin has described an emergency. Two decisions immediately fueled a change in the Constitution. The decision of the Supreme Court in Ramesh Thapar versus State of Madras, striking down the Madras Maintenance of Public Order Act, 1949, and Brij Bhushan versus State of Delhi, striking down the East Punjab Public Safety Act, immediately prompted the need to insert the word reasonable in Article 19(2), as well as new grounds of public order, friendly relations with foreign states, and incitement to an offense in order to allow the state to regulate free speech. One other article into the Constitution reflected the centre's concern to centralize power through the Constitution and enact property legislation. By the First Amendment, Article 31A and 31B were also added to the Constitution, which expressly saved laws providing for the acquisition of estates from being void on the ground that they are inconsistent with fundamental rights. Acts and regulations specified in the 9th schedule would be immune from the operation of Article 13. In keeping with the tense atmosphere into which India was born, the operation of the preventive detention law brought into focus a jurisprudential position by the Supreme Court which was deferential to the state. This was clearest in A.K. Gopalan versus State of Madras, where the majority held that Article 22, being a complete code relating to the preventive detention law, the validity of an order of detention must be determined strictly according to the terms and within the four corners of Article 22, and that its validity cannot be tested against Article 19 and 21. In other words, the fact that the fundamental rights were not a continuous stretch of entitlements, but isolated pockets of discrete rights, was the jurisprudence of our court, or the Supreme Court at that time. So the working of the Constitution in the first decade of its existence, in the context of a newly born nation looking to consolidate national unity, was characterized by deference to the state agenda. But to the exigencies of time, the Constitution adapted and endured. A developing body of comparative constitutional studies, studying the resilience of constitutions, has indicated that there are three features that exert an overwhelming bearing on their endurance. The first is inclusiveness of the Constitution. The second is its specificity. And the third, its flexibility. Our Constitution serves as an outstanding example of durability, in no small part due to the formal power of constitutional amendment granted to Parliament in Article 368. The power of amendment is the foremost expression of flexibility and has been exercised to reflect the march of time and the evolving needs and values of society. It indicates, above all else, the ability of the Constitution to adapt to changing circumstances. Since the enactment of the Constitution in 1950, Article 368 has been used extensively. As of October 2018, there have been more than 100 amendments to the Constitution, with amendments both frequent and wide-ranging. However, the flexibility of our Constitution is balanced by the need to protect the Constitution's character as a supreme law, insulated from the whims of the government of the day. This was achieved by virtue of the basic structure doctrine in Keshwanand and the jurisprudence of the Supreme Court that followed, which placed limits on the plenary amending power of Parliament, thus safeguarding principles that form the bedrock of our constitutional order. As a result, the procedure for amendment today is reflective of a finely struck balance. It is neither too rigid nor too flexible, blending pragmatism and adaptability with carefully designed safeguards. Indian constitutional history has borne witness to a number of landmark constitutional amendments. What was formerly the fundamental right to property enjoys the unique distinction of being the most amended provision in our Constitution. Protected as a fundamental right until the passage of the 44th Amendment in 1978, the right to property was thereafter deprived of its fundamental status to reflect the growing realities of a conflict between the protection of existing property rights and the desire to move towards a more egalitarian society, which would involve a redistribution of land. The 61st Constitutional Amendment of 1989, passed in recognition of political consciousness of the country's youth and the desire to integrate them into the political process, reduced the voting age from 21 to 18 for elections to the Lok Sabha and to the state legislative assemblies. The 73rd and 74th Amendments, which brought through the insertion of Part 9 a major boost to the protection and recognition of local self-governing models in India by providing a constitutional status to panchayats, namely the rural self-government, and municipalities, urban self-government. The 86th Amendment of 2002 recognized the primacy of education for the nation's youth, and through the insertion of Article 21A, made free and compulsory education between the ages of 6 and 14 a fundamental right and responsibility of the state. So we would miss the essence of the Constitution if we do not remember to dwell upon the institutions which the Constitution has created. Democracy thrives when institutions thrive, and democracies fail, nations fail, when institutions fail. So the resilience of our Constitution lies not merely in placing the individual at the forefront of its endeavors, but in terms of creating vibrant institutions. And these are institutions which really sustain our democratic structure. The makers of our Constitution were confronted with various tensions, which ultimately shaped the character of the Constitution. The Constitution of India is a text that governs over 1.2 billion people in 29 states, speaking 22 constitutionally recognized languages, not to mention hundreds of dialects, and practicing virtually every mainstream religion in the world. Indian constitutionalism has been described as a boisterous and contentious enterprise that strives to endow the largest, most diverse and complex democracy with legal form. The sheer diversity of the persons it governs throws up challenges in the nature of religious, cultural, and linguistic differences. Significantly, this diversity has led to contradictions in the Constitution. These contradictions were often in the form of a grant of a different status to a community, identity, or territorial region to preserve the plural social fabric of our nation. Rivaling the importance of a social revolution to be fostered by a transformative constitution were the goals of national unity and stability, considered as prerequisites for a social renaissance. The framing and working of the Constitution can be described as an attempt to balance the contradictions of a multicultural and multi-ethnic society, which, among other things, involves reconciling a secular state with a fundamentally religious society. Though the word secular state was introduced in the Constitution only in 1976, the secular nature of the Indian state was affirmed by the Constituent Assembly. During the framing of the Indian Constitution, a significant question arose as to whether religious and other groups should have separate and distinct political representation in electoral processes. While the Government of India Act contained provisions for communal representation in electorates, the policy of communal representation was rejected by the Minorities Subcommittee and the Advisory Committee. Finally, communal representation was done away with by Article 325 of our Constitution. The draft of the Constitution was a declaration of social intent. While rejecting political fragmentation on the basis of religion, the Assembly granted autonomy to religious minorities. The Charter of Fundamental Rights, based on the principle of non-discrimination, begins with Article 15 telling us that it applies to discrimination on the grounds of religion, race, caste, sex, or place of birth. The freedom of religion located within the Charter is expressed in 4 articles, 25 to 28. The centrality of secularism in the constitutional system was reinforced by the Supreme Court by assigning it in the decision in S.R. Bombay the value of a basic feature of the Constitution.